on item 8.
Item 8.
With the consent of my learned friend.
You want to withdraw?
No, my lord. Let it come after vacation, my lord.
Is it?
I have taken the consent of others.
Yeah. On the prayer of Mr. S. Datta, learned senior counsel for the petitioner, and prayer not being objected to by learned counsel for the respondent, let this matter be listed after 4 weeks.
Grateful to you.
My lord, these matters may come up for admission on Monday, my lord. Matter relates to non-payment of outstanding bills.
Where is the urgency?
Urgency.
It will come on its own turn.
My lord, it was supposed to come after 3 weeks. It was last listed on 15th of July, my lord. It did not come after that.
July, August only.
Yes, my lord. It was, notice was issued returnable by 3 weeks. So now it is August, my lord.
15 August. It was listed in 15 August. Let's see. Yes.
May be permitted to mention item number 1, my lord.
Yes.
And may I pray, my lord, this matter may be taken up after vacation, my lord.
Why?
Because, my lord, I could not contact my client, my lord. And I have, it is understood that, my lord, the respondent also withdrew from this case, my lord, management respondent.
Who?
Earlier it was SN Sharma, now K. Kolita, and they have withdrawn from the case, my lord.
So
So, my lord, I pray, my lord.
you're for item 1.
Item 1 and 2, my lord.
Mintu Sharma.
Mintu Sharma. Analogous matter, my lord.
He's working, still working?
Still, no, my lord. So I have to take proper instruction, my lord, because I could not contact my client. That is my problem, my lord. They are net talking phone, my lord.
MS A. Bhattacharya, learned counsel for the petitioner, submits that she could not contact the petitioner. Therefore, press for some time. Press for listing of the matter after
Vacation.
After 4 weeks. List of. He may not be interested to pursue also.
No, for that, my lord, I have to take instruction, my lord. If they are not contacting me, I will have to withdraw from the case.
No, you cannot. You just cannot withdraw.
That's why I'm waiting for the response.
Considering the matter pertains to 2014 and 16, come on. Prayer for adjournment is granted as a last chance.
Okay.
Accordingly, list after 4 weeks. 1 and 2. Yes.
1 and 2.
May I please, my lord, is a 16th matter, my lord. My lord, the matter pertains to my lord ex gratia grant, my lord.
Huh?
Ex gratia grant.
Huh.
My lord, it was lastly listed on 17/7/2023, my lord. Till then, my lord.
My lord, with regard to item number 9, lordship, I have been engaged newly in this case, and the entire records are yet to be handed over, lordship. Item number 9. Maybe it may come up next week, lordship.
What is there?
Lordship.
What is there?
Lordship, we are aggrieved with the closure of our wine shop and restaurant, lordship. There is some urgency. Let it come Wednesday or Friday, any day.
You will take it up today?
Lordship, the copies of the affidavit are not handed over to me yet. That is the only difficulty.
When you were engaged?
Engaged around 15-20 days back, lordship, I filed a vakalatnama.
15 days back. We have read it last night only.
Lordship.
One day before.
Lordship.
We have read the brief last night only.
Lordship.
So you had the 15 days.
Lordship, Wednesday or Friday, any day, lordship. There is some urgency in the matter also.
After 4 weeks.
No, lordship. That will be very difficult.
Your name, please?
A. Ganguly.
But your name is there.
Yes, no, I have filed my vakalatnama now.
You said you have been engaged recently.
No, I have filed vakalatnama. Earlier, it was conducted by Mr. A. Somu, lordship.
Okay, on the prayer of Mr. A. Ganguly, learned counsel for the petition, list this matter after a week.
I'm grateful.
May I please, lordship?
Yes.
So I beg to mention item number 5, my lord.
Yes.
In this case, we are challenging lower court award, my lord.
Yes,
My lord, the records pertains to lower court record is
it's there.
vernacular, my lord.
Is
Lordship
it?
may not be comfortable, so
How do you know?
if lordship willing to take up, I have no.
Anyway, Mr.
M. Hunter.
M. Mohanto, learned counsel for the petition submits the trial court records are in vernacular, therefore request for listing the matter after 2 weeks,
Yes.
so as to enable. Can you translate it?
No, my lord.
Relevant.
No, my lord, because
We require the evidence only, deposition.
lordship.
How many
Lordship.
witnesses were there?
Documents, including evidence filed by the.
Yes, how
workmen.
many witnesses?
There are
Evidence.
3 workmen, my lord. All evidences are vernacular. And apart from that, since it is pertains to disciplinary proceeding, my lord,
Hmm.
and communication and.
So as to enable him to translate the relevant.
No, not required to translate, but because if lordship is comfortable, then I have no problem. Otherwise, he
No,
has
it's
to.
not a question of comparable. I may not understand. You may be correct.
Lordship. Lordship.
So you can translate the relevant, at least the depositions, the evidences.
No, that will take more, otherwise,
Huh?
lordship may observe to list before any appropriate bench, that will.
No, that cannot be. Why, when in language, it's a Japanese or Korean?
Lordship?
It's a Japanese or Korean?
No, Assamese, my lord.
Then Assamese is an Indian language.
Lordship.
So
Now, if lordship willing to take up the matter, I'll.
why can't you translate it? They're relevant, not all the records.
That is perhaps.
We just would like to see the evidences. Evidence you could translate it.
It will be difficult for me because.
You also not
Nah,
comfortable with the
otherwise, you
Assamese.
have to, lordship may direct the registry and translation run that will also.
What is the system here? By the registry.
Registry.
Now we'll list after 2 weeks, you find out what is the relevant, we just want the evidence only,
Lords.
not other records. Isn't it?
Lords.
List, what is it? Vernacular, huh? No, after 2 weeks, list of priors allowed. The registry to translate the relevant depositions of the witnesses. How many witnesses?
To my knowledge, below 3 workmen filed their evidence
Ah.
in vernacular,
Ah.
and along with their earlier communication in connection to.
Earlier, forget it. We'll ask, during the course of hearing,
But
you just translate.
Cross-examination part is in the English medium.
So to direct registry to translate the evidences, public depositions filed by the
Workman.
workmen.
Workman as well.
What about the management?
Management part is in English.
Okay. That's all. After 2 weeks.
My lord, I beg to mention item number 6 and 7. With the concern of the other party, matter may be adjourned today.
Why?
My senior is not at
Who is your senior?
BK Singh. He's attending another bench, my lord.
Anyway, okay. On the prayer of so and so, learned counsel appearing on behalf of Mr. BK Singh, for the petitioner, on the ground that Mr. Singh is engaged in some other courts. Come on. Let this matter be listed after 4 weeks.
No, my lord, fixed date may be given.
4 weeks.
Will not 16 or 23/9.
List on 16/9. You have no objection.
They are out of station, my lord, I'm
Hmm.
told. But then it has been adjourned repeatedly, my lord, at their instance. These are workmen,
16,
my lord.
16-9.
Yeah, please, Your Lordship.
3 and 4.
No, Lordship, I'm praying for listing of a matter, Lordship.
What is the urgency?
Urgency is that the chairman of the board of trustees, Lordship, we are basically the plantation department, Lordship. Plantation Private Limited, Lordship, Bagasa Plantation Private Limited.
New
Lordship,
matter?
Lordship,
Is it a new matter?
Yes, Lordship, fresh matter for tomorrow, Lordship.
No, you file it, it will be listed.
Lordship, tomorrow, Lordship.
You
the
first,
urgency is that
have
we
you filed it?
Yes, Lord.
Have you filed it?
Yes, Lordship. Today only we are filing it.
Now?
Yes, Lord.
Filing is completed.
Yes, Lordship. It is on process, Lordship.
So it's not complete. We'll see. Next week,
Lordship,
Monday.
the problem here is, Lordship, we have
Yes.
been directed to pay the PF fund, Lordship, from the month of August, Lordship. So that direction may be taken for consideration, Lordship. Now, what has happened, Lordship? This is the second round of litigation, Lordship.
We'll see on Monday.
Monday, Lordship.
Monday.
May it please your lordship. Lordship, I beg to mention for listing a matter for Wednesday, lordship.
Why?
Or Friday, lordship. The matter relates to de-voter, lordship.
Hmm.
Similar petition has been disposed of by this honorable
Hmm.
court, lordship. Oblige your lordship.
May I please, your lord? I'd like to mention for listing in the admission column on matter, my lord, in the matter of 2023, my lord. It was supposed to come after 3 weeks from March, my lord.
After a week.
My lord.
Meet this lordship.
Yes.
Lordship, with the concern of the other side, I beg to mention item numbers 9 to 24 of the submission list.
No adjournment.
Lordship, the learned advocate general.
There's no case today.
But lordship, today it won't be possible because.
There's one motion matter. If it is adjourned, finish.
Lordship, in this matter, lordship, he's engaged in a part with, in 2-3 part with matters.
No, we'll
lordship.
take up at 2 o'clock. Don't worry.
Lordship, 2 o'clock also he has some difficulty. Lordship,
This matter.
3 o'clock.
Lordship, little commission not today, lordship. Any
No,
part
on
today,
your
lordship.
prayer only on the
This
other
matter,
day for yesterday.
Two coordinate bench of this honorable court has released this matter because of the adjournment. I have argued, third time I have argued before your lordships. And every time, my lord, there is a prayer from the other side, therefore it was released twice. And how can this be permitted?
Only a learned advocate general has to be heard. It has
Yes.
been, we have heard already.
It's over, lordship. Only our play needs to be given, lordship. Any day other than today, lordship. Lordship, that is my.
Tomorrow then.
Yes, lordship.
Tomorrow.
Yes, lordship. Not today,
No,
lordship.
other day also you said today on your prayer only this has been
Lord-
fixed today.
Either
Not you. Mr. Nayak was there.
Lordship, either learned advocate general or is not Lordship, Mr. Nayak,
There's no
lordship.
case in
It
the
is
on the,
AG will appear, lordship.
there is no case on the board now. That's why these fixed matters has been listed today. Otherwise, it would not have been listed.
Lordship, today, lordship, some accommodation, lordship.
Tomorrow.
Lordship, if possible, Monday. If
No, Monday is not possible.
then lordship, 4th, lordship.
No, there's nothing much to be heard. In fact,
Lordship, today, lordship, it won't be possible, lordship, because
3 o'clock,
lordship, then tomorrow, lordship.
4 o'clock,
Lordship, then tomorrow, lordship.
5 o'clock, 6 o'clock, I'm also ready to take up. There's no matter today. Sir, what to do?
Lordship, additional AG will appear if lordship necessary, but not today, lordship.
No, we will
Lordship,
hear,
tomorrow,
we
lordship.
will not hear other than the learned advocate general. We have adjourned this matter because the learned advocate general is appearing, is when requested to appear. Therefore, we are adjourning every day. It's in, I think, third or fourth time.
Lordship, last time,
It's not that it's not the question. I mean, it's not that this court doesn't want to, accommodate. But problem is, you have to see our problem also. I'm jobless. And fortunately, I have no CAB also. No pending matters. No judgment to be written.
little accommodation only for today, lordship. Lordship.
Which he is engaged in part-hard method.
Yes, lordship.
This is equally part-hard method. Is it before the division bench?
Yes, lordship, before division bench.
I'll request Chief Justice to release him for 1 hour. Sir, what to do? Tomorrow. No further adjournment.
Lordship.
On the Miss MS R. Barua, Learned Council appearing on behalf of Learned State appearing on behalf of Mr. D. Soike, Learned Advocate General, submits that the Learned Advocate General is engaged in some part and method before the division bench. Therefore, praise for listing of the matter, that is supplementary. 11 to 24. What is this? Praise for little accommodation, fixing the matter preferably tomorrow, that is 29, So, although this court is not inclined to adjourn the matter in view of the fact that matters are apart heard and have been adjourned for many times. This, however, considering that the Advocate General is engaged in some part of matter, other part of matter before the division bench, as a last chance, I mean, as a last opportunity, let it be listed, let these matters be listed tomorrow, 29. Yes.
Made please, Lord.
Yes.
My lord, these petitioners, they are all, my lord, small-time businessmen, my lord.
Yes.
They are basically supplying school uniform to elementary education schools, my lord. Now, my
Yes.
lord, for the last financial year, that is 24-25, they were successful in the tender process and they were awarded works and which they completed. It so happened, my lord, in respect of few schools, there were some complaint regarding the quality of the material supply. So there was a direction issued by the authority to replace those, which we did. Therefore, final payments have been made and everything has been done. So there is no other complaint as such. Now, what the authorities have done, my lord, for the current year, they at page 44, they have published a list of vendors. Kindly see, my lord. List of vendors whose lab test reports are not as per requirement in the last year. Now, my lord, if your lordship would kindly come to page 45. Now, serial number 3 is petitioner number 16. Then serial number 4 is petitioner number 4. Serial number 6 is petitioner number 9, and so on and so forth. Now, whosoever's name is appearing in this list, my lord, now they have not been able to register, my lord. Now, if your lordship would kindly come to page number 60, my lord, 62. Now, by one petitioner, my lord, when he tried to log in that Shiksha Setu, then, my lord, we could not. Now, it is reflected as invalid username, etc. So, we could not register. Now, then when we further inquired from the, my lord, present tender, then we got to know the reason. Now, the present tender lordship's will guidelines is at page 49. And if your lordship would kindly come to page number 53, my lord. Now, different aspects are there. If your lordship would kindly come towards the bottom, role of headmaster, teachers, etc. See, only those vendors who are registered in Shiksha Setu will be allowed to participate in the tendering process. Page number 53, my lord.
53,
It was the last two lines, my lord. It's in bold. Only those vendors who are registered in Shiksha Setu will be allowed to participate in the tendering process.
Yes.
Now, when we wanted to log in, my lord, we could not. As I have reflected in page number 62. Now, if your lordship kindly comes over to the next page, page 54.
Hmm.
Vendors were blacklisted due to supply of substandard quality of uniform during 23-24 and 24-25 shall not be considered to participate in the tendering process as also in quotation. Therefore, my lord, without any notice, without anything, we have been virtually made, my lord, blacklisted. Now, how this is possible, my lord? Supreme Court has said there's a particular procedure established by law has to be followed. Now, as a result, what happened, my lord? We are not in a position to participate in the tender process because unless we register ourselves, we cannot participate in the tendering process. Now, they have treated us as if we stand blacklisted.
Yes.
On the contrary, my lord, yes, I'm not saying there were some shortcomings in the supply which were intimated to us, which have all given the documents and which we supplied. And thereafter, there is no complaint, final bill has been made. Now, therefore, my lord, our right to livelihood is being, these are all small-time businessmen, my lord. Now, the last date is 31st. So, my lord, they will not accept our tender online because of the system is such. Now, they should accept our, my lord, tenders which will supply manually. Now, I'll just place the Supreme Court judgment, my lord, on this point. And the schools have started issuing quotation, my lord. Now, if your lordship should kindly come to paragraph 21 at page 562. This is, my lord, 2021 2 SCC 551.
Page, para?
Para 21 at 562.
Yes.
Thus, from the above discussion, a clear legal position emerges that for a show cause notice to constitute a valid basis of blacklisting order, such notice must spell out clearly or its content be such that it can be clearly inferred therefrom that there is an intention on the part of the issuer of the notice to blacklist the noticee. Such a clear notice is essential for ensuring that person against whom penalty of blacklisting is intended to be imposed has an adequate, informed, and meaningful opportunity to show cause against his possible blacklisting. Then, my lord, will kindly come to para 25, my lord. A similar position as in our case. The mere existence of a clause in the bid document which mention blacklisting as a bar against eligibility cannot satisfy the mandatory requirement of a clear mention of the proposed action in the show cause notice. The corporation notice is completely silent about blacklisting, and as such, it could not have led the appellant to infer that such an action could be taken by the corporation in pursuance of this notice. Had the corporation expressed its mind in the show cause notice to blacklist the appellant, could have filed a suitable reply for the same.
Show cause was issued.
No, my lord, nothing.
No, in this case.
In this case, show cause issued, my lord. But there was no clear intention expressed. Supreme Court says, no, even this will not serve. Now, in our case, my lord, there is no proceeding for blacklisting. So, by implication, and my lord, yes, I'm not saying there was not some infirmity in the quality part, which we have replaced. Now, my lord, the clause in the tender at page 54, which virtually blacklists us and debars us from participating. In our case, there is no show cause notice. Therefore, my prayer is, my lord, subject to further orders to be passed by this honorable court, because supplies will commence from 31/12/25. By that time, my lord, the supply has to be concluded. So, my lord, our tenders should be accepted manually. That is our interim prayer, my lord. Subject to further orders that may be passed. And, my lord,
How this page 44 list of vendors list or not?
Page 44, my lord.
Yes.
Yes.
How you obtain this list?
From the website, my lord.
Is it not a kind of notice
No.
to you?
They have only, no. This is only a list they have published.
Internal, their.
They have published a list according to them who are ineligible.
And this copy has not been served to you?
No.
Yes, sir.
So far as this list is concerned, it has already been uploaded in the website, Lordship, from which they downloaded and annexed this copy. So it is to their knowledge, but I am not on that point, Lordship. If Lordship comes to the tender document, Lordship, that is starts from page 53. The two issues are there, Lordship. Page 53, if Lordship comes to H, committees for evaluation and monitoring. If Lordship comes to 1C, this is regarding registration.
53.
Page 53, Lordship.
Hmm.
Down below, Lordship, last two lines. Only those vendors who are registered in Shiksha Setu will be allowed to participate in the tendering process. So this is one procedure, that is registration. And the next page, if Lordship comes to D, the vendors who were blacklisted due to supply of substandard quality of uniform during the year 2023, 24 and 24-25 shall not be considered to participate in the tendering process and also in quotation process. Now, they are at the stage of registration. They are unable to upload their documents for registration.
Because you have blacklisted them.
Where is the document, Lordship? They are not saying that, they are only apprehending. They are only apprehending that we have.
No, they say they try to.
Page 62.
Yes. They made an attempt to upload. I mean, registered.
Yes.
Yes, what they have failed is to register, Lordship, not for tendering. Before that, in the Shiksha Setu app, they have to register. Only then they will be able to submit their bid, Lordship. 53. So that page 63 is there. In this connection, it is to be mentioned that government has approved relaxation in GST registration. That is not last three line, Lordship. However, at the same time, all firms who supplied poor quality material will remain blacklisted. For blacklisting also, there is a procedure.
That you have not followed. That's what they're saying.
Yes, Lordship, that is what I'm saying. They are still not, they are only apprehending that they were blacklisted. That is their apprehension.
Not
for what reason they are unable to register themselves, Lordship. That instruction they also do not have.
Because it says that you will not be allowed to participate, blacklisted.
No.
Those who have been blacklisted, they will not be allowed to participate.
Allowed to participate where, Lordship? In the tendering process.
Yes.
They are unable to register themselves. They are at the one stage ahead, Lordship. Let them register first, then they will participate.
If they cannot, you should page 62.
No, what I'm saying, Lordship, the reason why they are unable to register their name, Lordship, they are also not aware. I am also not aware at this stage, Lordship. So what I'm saying, submitting, Lordship, let this matter come tomorrow, Lordship. 31st is the last day. Tomorrow I'll place the record, Lordship, whatever instruction is necessary, Lordship.
No, tomorrow it's not be possible.
Yes.
Will you accept suppose in case if this court passes an order that the tender should be accepted manually?
No, if Lordship passes such
Saturday, Sunday is holiday again.
No, if Lordship passes such an order, definitely we will have to comply. But my submission will be why Lordship will pass such an order. It is a tender process, online tender process.
No, we'll see.
This is an online tender process.
We are in the midst of hearing to you.
Not yet.
That's why in case.
So my submission is very simple, Lordship. Let this matter come tomorrow, Lordship. It will take 5 minutes for your Lordship. Let me place the instruction why they were not allowed to register their name. That much only, Lordship.
Milord, can I come in, Milord?
Yes.
So Lordship, to kindly come to page 58. Other than registration, everything is manual, Milord. It's not online. 58. One of the notice issued by a particular school, Milord. So-and-so invites quotation from supplier for supply of school uniform. Interested supplier may obtain the tender documents from the inviting authority of SMC. Tender document will be issued up to 22/8/25. Tender will be received up to 26/8/25 till 2 p.m. and it will be opened on 27/8/25 at 20. So suppliers shall have to register in Shiksha portal and the registration shall have to be mentioned in their quotation. So my lord, first once we get the registration, then manually everything will be done. Now, my lord, we have not been able to register because our name appears in that list. And indirectly, my lord, they have blacklisted us. And my learned friend is unnecessarily creating this confusion, my lord.
I'm not creating confusion.
Yes, you are creating
Comes to
confusion.
page
You are
58,
saying-
Lordship.
you are
Lordship,
saying
kindly
it
see
is
the
one
last
step
page,
ahead.
Lordship.
Oh, this, your tender pertains to which school?
My lord, there are so many hundreds of thousands of schools are there indeed.
But so far as
There are 14,000 schools.
this
in
NIT is concerned, it's over.
No, no, my lord.
Lordship will see the date, last date.
In 1 or 2 scale, it is over. My lord, the process has just started. There are 14,000 schools in the state.
Okay.
And all these SMC school managing committee, wherever the value is less than 1 lakh, it will be, my lord, limited tender. And in case the value is above 1 lakh, then it will be an open competitive tender. Now, my lord, our only problem is we have not been able to register because our name appears in that list. Indirectly, that means we have been blacklisted.
Page 61 or page 60.
And for example, at page 61, last date is today. Sorry, last date is today. It's a different school. I have just given for, my lord, illustration. It has started. We have given examples of only 2 schools, my lord. There are 14,000 schools in the state. Therefore, our only, my lord, prayer is we should be allowed to participate in the process, subject to further orders. And the last date is 31/8 submission. And the last date of submission is 31/8, and by that date, my lord, everything has to be closed.
I'm limited to show that the work orders are issued within 31st. Within 31st.
Yes. There is hardly any time left, my lord.
What records you will produce?
No, only the instruction, why they are unable to register their name, Lordship. That much only, Lordship.
No, my lord, that
Then
can
not to
await.
pass the
No,
order.
no, what I'll say, my lord, I'm saying is,
It is a
it
necessary
will not,
instruction.
no, 31st will be, once it is over, we will be in trouble, my lord. So let us participate. Let my learned friend file his affidavit.
You may not
Accept-
accept their quotation also.
No, this is an
You may
online
reject it
process.
also.
This is an online process, Lord.
Online process is
Online
for
process.
registration.
No, yes, Lordship. That registration is already over.
See, tomorrow if we find that the on their fault, not because of the blacklisting, they could not register themselves, will not allow.
No, that whether they were blacklisted or not, that instruction I am not having at this stage, Lord.
You see, it's the vendors who were blacklisted due to supply of substantial quality of uniform during so and so shall not be considered to participate in tender process and also in, because the registration is the first initial.
Kindly see the word, they material will remain blacklisted. It's an action done in the past, Lordship.
No, that's why what they are saying
So
is
they are not saying that we are blacklisted. They have not yet stated. They are only apprehending that we have been.
what they are saying is because of this list which you have published, it amounts to blacklisting them. Therefore, they could not register themselves in the SETU.
No, I'm not accepting that, Lordship. That is a list.
You may not
Lordship.
accepting what
Lordship,
their submission is there.
If Lordship comes
What
to
they
page
submitted is that.
page 41, Lordship. This is page 41.
Yes.
This is the leftist report, Lordship.
Yes.
Example. Lordship, kindly say this is only this list is annexure of this document, Lordship.
Yes.
So this was done in the month of March 2025. So definitely, Lordship, these persons have the record of supplying low quality materials, Lordship. That is there.
So we'll take it up at 2. You take instruction.
Lordship.
Why they could not register them?
Yes.
Lordship.
Otherwise,
My lord,
we'll allow them to participate.
my lord, can I make one small prayer, my lord?
Unless you show that it's because of their fault, it's not because of that they've been blacklisted or debarred from registration. At 2, we'll take it up.
My lord, can I make one prayer, my lord?
Yes.
Will it be inconvenient if it is 12:30? Some difficulty at 2 o'clock.
12:30.
12:30, now it is 10:30. My learned friend will be
Yes,
instructed.
Already relevant documents to the authority, Lordship. If I receive, Lordship,
No, let us fix the date,
Ah.
fix the time.
What,
Make it-
12:30?
Let it make tomorrow morning, Lordship, at 10:30.
No, it's
Nine.
not of you. We'll take it up to.
12:30, my lord. If it doesn't come at
You-
12:30, we'll wait up to 2, but let my learned friend try, my lord.
Lordship.
Yes,
Deep level.
a superintendent. Yes,
Lordship, in this case, we have challenged the order passed by the Learned Labor Court,
yes.
wherein the dismissal order of the workman, that is the respondent number 1, was rejected, and he was directed to be reinstated in the service with all back wages.
Hmm.
Your Lordship,
Yes,
Here, your Lordship, so far the respondent number 1 is concerned, he was a workman under the management of petitioner. So during his service, there he was found guilty of gross misconduct in his duty. Therefore,
particularly.
particularly defalcation of company's fund.
Hmm.
Subsequently, we made an inquiry, domestic inquiry.
Hmm.
In domestic inquiry also, he was found guilty, and therefore he was dismissed from the service. So, of the dismissal of service, the matter was referred to the labor court. Then labor court dismissal order was rejected and directed to be reinstated in the service along with payment of all back wages. My preliminary objection before this honorable court is that whenever a matter goes to the labor court by way of reference against the dismissal which was done after domestic inquiry, the first and the foremost actions which to be taken by the labor court, your lordship, is to first frame a preliminary issue with regard to the domestic inquiry, whether it was done fairly, whether there is any violation of natural justice. That issue ought to have been decided first, preliminary, and then labor court can proceed further. But in this case, that procedure has not been adopted by the Learned Labor Court. This is my preliminary objection, your lordship. And if your lordship, for this purpose, I would like to rely a judgment. I'm just cutting short my argument.
First, you tell us the facts.
Facts is that, your honor, this workman, he was the owner of this tea company. It's a tea company. He used to prepare the list of hajiras, this workmen. In particular day, how many workers has worked. He used to prepare list. Then as per the list, he used to collect money from the company's fund. And then he distributed to the laborers as per the work done by the laborers. So what was found, that he used to prepare false hajiras of the workmen. Suppose if 10% has worked in a particular day, he used to prepare the list of 15 laborers. The 15 laborers found he used to collect from the company, and 10 is paid and rest goes to his pocket. Perhaps it must be deemed that it goes to his pocket. So ultimately that was found during his service, which you all know will. And thereafter immediately he was served notice, and against the notice he is admitted. He is admitted. Your Honor, may kindly come to page 33.
Notice was issued to him, he admitted it.
Admitted.
33.
Before that, Your Honor, lordship may kindly come to page 32. Page 32, Annex 3.
Notice.
Notice. It is noticed and detected with great concern that you are very much involved in the defalcation of company's money. In your pay sheet of week ending so and so, plenty of anomalies are found which are of serious nature. You are providing false hajiras to women workers to pay sheet in book number 2 on payment day of 20th September 2014 for week ending 13 September, a sum of rupees so and so deposited to the office where so and so is shown excess and so remain unpaid of listed workers. Sri R.S. Thakur and Sri B. Nath were on the payment table. The unpaid listed workers called to collect their wages payment on 23rd and 24th September. But only 16 numbers of women workers came to collect their wages and balance money remained unpaid and seems to be under false hajiras made by you while preparing input sheets. There are other anomalies too in your paybook, like amount of workers shown different, paid different. Your willful misappropriation of companies' money comes under gross misconduct under section 10A of 2 and you are.
Of what? Is under section 10A2 of?
This is a standing order. There is a standing order. Perhaps that is missed here.
Hmm.
And you are hereby charged, seated, to explain writing why disciplinary action not to be taken against you. Your written reply should reach to the undersigned. So and so then from receipt of this letter, otherwise stern action will be taken against you as per the standing orders applicable on the state. Then you'll also come to page 33.
Hmm.
This is the reply.
Hmm. Yes.
Respected manager, this is the reply of the workman.
Hmm.
I humbly state that I am very much embarrassed on the receipt of letter. This is translated copy also.
Hmm.
Second one is the Hindi. It was in Hindi.
Ah.
I humbly state that I am very much embarrassed on the receipt of letter so and so from company. What was happened that a sum of so and so well fell short on the day of disbursing bonus payment so and so. I thought as a company's money fell short because of me. So on the same day, I put cut marks in connection with some liberal payment with pencil in the payment sheet so that I can get that money and give it to the company. But later on, I realized that I think my thinking was wrong and I should not have done so. And I am very much embarrassed by it. Therefore, I humbly pray before the respected sir with folded hands for forgiveness for my first and last mistake. And such mistakes never repeated. Otherwise, you can punish me in whatever way you like. So, virtually admitted that he has committed wrong, though he has tried to give some other color to it. But ultimately, domestic inquiry was done. Prior to that, notice was also given. And the domestic inquiry report, your lawsuit will find it's page 37.
Hmm.
Page 37 is a domestic inquiry report.
Hmm.
And the finding of the domestic inquiry report, your lordship will find page 41. Last paragraph. Last paragraph. I hold the CSW, charge sheeted workman, Sri Mohan Gope, guilty of gross misconduct under so and so of the certified standing order in force on Dumni Tea Estate.
Hmm.
So, in view of this domestic inquiry report, he was dismissed from the service.
Ah.
Even after service, will also,
Yes.
even after service, then we again serve this notice after charge sheet, this report. Then he has written a letter to us, which you also will find at page 49. You see, got 49.
Hmm.
Respected sir, I beg to inform you that in the report of inquiry which initiated against me, in which the discrepancy of so and so was detected out of so and so fell short during time of bonus payment, for which I have written the manager that I had told so and so before weekly payment itself, I will pay it from my weekly payment and you are not required to pay. Now he want to say that he will pay from his own pocket, the sort of money, pay from a weekly payment and you are not required to pay. Therefore, I intended to deduct the amount so and withdraw it. And respected sir, for this mistake, I had already called upon your forgiveness by writing to you, and today also I am calling upon you, calling upon for your forgiveness with folded hands, as my whole family is dependent on me. The education of my children is incomplete. Hence, considering my children's future, let my job remain intact and give me any other punishment but save my job. So he is admitting all along. Then what he did, you see,
Then you'll also be kindly see the page 51. Page 51 you'll also.
Dismissal is page 59, 51.
Yes, after this order,
Hmm.
this inquiry report,
Hmm.
this is this again, after this issuance of this 51 letter, he has issued one letter, this respondent, which you also will find as 52.
Hmm.
Respected sir, I beg to inform that I was working as an employee in your garden. However, due to personal difficulty, I am tendering my resignation. Now he tendered his resignation, your lordship.
Hmm.
I humbly pray, hold your hand to forgive all my small and big mistakes. Yes, again admitting. However, due to my personal difficulty, I am tendering my resignation letter from my job, and I humbly pray with folded hands for forgiveness for all my small and big mistakes that I have committed during my service. And by seeking every officer's and Babu's forgiveness, I humbly pray before God for well-being so and so. So as he was working in our company, so the company also showing its magnanimity, this his resignation was accepted, which you also will find it page 54.
Hmm.
In the meantime, this matter was referred to the industrial tribunal, labor court.
Hmm.
And the labor court, both the parties filed their written statement.
Resignation was accepted.
Yes, Your Lordship.
Huh?
Accepted. As he has admitted his mistake, for being a workman for the company for the last couple of years, so we have accepted his resignation.
By this page 55.
Yes, page 55.
Hmm. Then
Matter went to the reference, to the tribunal by way of reference. Both the parties submitted their written statement. And we have all along relied upon the inquiry report, domestic inquiry report, which was done following due process of law, and full opportunity was given to him. But ultimately he was found guilty in the domestic inquiry report. Now, the labor court, while rejecting domestic inquiry report, I mean the dismissal order passed by the management, did not discuss at all with regard to the domestic inquiry report, Your Lordship. And there is no preliminary issue framed to that effect. So my first and preliminary submission before Your Lordship, that Learned Labor Court committed grave error by not framing a preliminary issue with regard to the finding of the domestic inquiry report. There is no whisper at all with regard to the domestic inquiry report in the impugned order.
hmm. Impugned what is?
Impugned order, Your Lordship will find page 85. If you go to
Yes.
the operative portion, you also will find page 101. Onwards. At the same second.
This
second,
page 95 is it's a translate copy, the typed copy.
No, it's a copy issued by the labor court.
Then what about page 85?
Two copies perhaps by mistake, two copies has been given. One is a certified copy, one is copy which was served upon us. The certified copy starts from 95 page.
Yes.
Page 101.
Hmm.
First paragraph, second paragraph. At the time at the same time, it has also come before the court that a payslip so was not prepared by Workman Mohan Gope. Workman Mohan Gope admitted in his evidence that Exhibit C was prepared on the basis of Hajira furnished by him. So he is admitting to the management. During evidence, no direct questions were put to Workman Mohan Gope, so and so. The question of asking any question on that particular documents which was prepared by him and which has been admitted by him that it was prepared by him. So there is no question of asking any other questions. However, the management smelled a rat. It's very important, Lordship. However, the management smelled a rat, so the management entrusted MW3 and MW4 to distribute payment to the laborer on the basis of Exhibit 15. So Exhibit 15 was prepared by the respondent number 1, where subsequently the management found that there is excess in the number of workmen. So on the payment day, other 2 persons were entrusted. So when they started distributing this payment to the wage, this worker, it was found that there is excess names in the work list. Then actually who worked there? Because the names which were called for the payment, nobody turned up. Meaning thereby, he has given a false hajira of few numbers of people, these workers. So here a question comes that if the management had the occasion to suspect so and so names of some women workers were shown as present, but actually they did not attend, then why the matter was not brought to the workman and why he was not so caused immediately? He was so caused. It has come to the, it has not come in the evidence of the management that before the payment of the so-and-so was made, an attempt was made to call the absentee women workers who were shown as present in the so-and-so and to verify the hajira. But it was done, alleged to have been submitted by the absentee worker. The absentee women worker also have not been summoned to this court by the management. Another interesting fact in next para. Another interesting fact is that as per the MW2, Workman Mohan Gope saw 34 women workers present, and from the material produced by the Mohan Gope, Exhibit 15 was prepared. A sum of rupees so and so has been shown unpaid, the wages of 34 absentee workers. There are some pencil do mark in Exhibit 15. Accordingly to the management, they were made by the Workman Mohan Gope, but it has not been specifically described before this court as to why such marks were made. A sum of rupees so and so was shown excess in the Exhibit 15 by MW3 and MW4. But there is no evidence why the excess sum occurred. It is already stated the excess sum has occurred because no person had worked. There is no whisper that Workman Mohan Gope had any previous record of defalcation on financial irregularity. So this is absolutely irrelevant, Your Lordship. The learned advocate for the management has strongly pleaded that Workman Mohan Gope admitted his guilt and begged apology in his so-called reply so and so. It is admitted. But here we cannot ignore the fact that Workman Mohan Gope pleaded guilty for an incident occurred on so and so when the bonus payment to the workers was made, but according to the management, so and so Workman Mohan Gope was not allowed to disburse wage on book number 2. Therefore, it stated the admission of the guilt by the Workman Mohan Gope was not in connection with book number 2. The management first put Workman under suspension on the basis of admission, and inquiry was initiated. In the inquiry report, deliberation was made on the sixth admission by the Workman Mohan Gope. So it is admitted. Deliberation was made in the inquiry report. But the interesting fact is interesting fact in the said letter referring so and so faced by the workman along with requisition, management informed the workman that explanation so and so submitted by the workman against the charge was not satisfactory, therefore not accepted. No second chance was given to the workman to explain the charge thereafter. It is absolutely wrong. He was given full opportunity. So, but the management relied upon the said so-called reply dated so and so before this court and demanded approval of the order of dismissal passed against so and so. How the document will come for consideration for are rejected. When document is found to be not accepted to the authority and there is an order on it, the same cannot be taken for reconsideration. The inquiry officer relied upon the said rejected reply Your Lordship, this document was not rejected. His explanation was rejected. This is a very erroneous view has been taken by the Labour Court. We have rejected his explanation, not the document. This is against the ethical so and so good conscience. For the above reason, it's a proof that Mohan Gopre was dismissed for no fault on his part, and it is not proof that he had no intention to defraud the company money by preparing false agreement. This is the finding of the Labour Court. But again, I will come to the first point, Your Lordship, the domestic inquiry report, that there is no discussion with regard to the domestic inquiry report, which was done by following due process of law. First, the Labour Court ought to have discussed with regard to the domestic inquiry report, whether it was done properly, whether it was followed properly, whether natural justice, rule of natural justice was followed or not. All these things ought to have been discussed first. If there is no such, if the finding is against that, then definitely then Labour Court would have gone ahead to discuss the evidence which was placed before the Labour Court. So for that purpose, Your Lordship, I would like to rely judgment.
Your main trust is only that the Labour Court has not discussed the domestic inquiry report.
Yeah, apart from that, there is other issues also. But if Your Lordship decide this issue first, then perhaps Your Lordship will send it back to the Labour Court to decide this issue first. Paragraph 22. Paragraph 22. Paragraph 22, Your Lordship. Page 6. Yeah. We are therefore, Your Lordship, got it? We are therefore clearly of the opinion that when a case of dismissal or discharge of an employee is referred for industrial adjudication, the Labour Court should first decide as a preliminary issue whether the domestic inquiry has violated the principle of natural justice. This is the crux, Your Lordship. When there is no domestic inquiry report or defective inquiry, this is not applicable in our case. But first, the dismissal or discharge of an employee is referred to the industrial adjudication. The Labour Court first decide as a preliminary issue whether the domestic inquiry has violated the principle of natural justice. When there is no domestic inquiry or defective inquiry is admitted by the employer, there will be no difficulty. But when matter is in controversy between the parties, that question must be decided as a preliminary issue. So this is what I would like to place before Your Lordship, that in this case, nothing such has happened. No discussion with regard to a domestic inquiry report. Relying upon this judgment, Your Lordship, the coordinate bench of this High Court has held again that it has to be decided first, and as it was not decided, therefore the matter was remanded back. That I will place that judgment also, Your Lordship. 2023 5 GLT 850. Paragraph 27, Your Lordship. Page 12. Justice Manish Chaudhary is in this. Paragraph 27, Your Lordship. It is settled that, Your Lordship got it? It is settled that a writ of certiorari is issued in exercise of extraordinary jurisdiction under Article 226 of the Constitution of India. The writ jurisdiction extends to cases where orders are passed by court or tribunals or authorities in excess of their jurisdiction, or as a result of their refusal to exercise jurisdiction vested in them, or they act illegally or improperly in exercise of their jurisdiction, causing miscarriage of justice. A writ in the nature of certiorari under Article 226 of the Constitution is issued for correcting errors or jurisdiction. When a subordinate court or tribunal is found to have acted without jurisdiction by assuming jurisdiction where there exists none, or in excess of its jurisdiction by overstepping or crossing the limits of jurisdiction, or acting in flagrant disregard of law or the rules of procedure, or acting in violation of principle of natural justice where there is no procedure specified and thereby occasioning failure of justice. From the discussion made above, it has clearly emerged that learned labor court in the process of adjudicating the reference, why or what dated so-and-so had confined itself in considering only the evidence laid by both the sides before it after reference, without first reaching any finding whatsoever as regards the validity and propriety of the domestic inquiry proceeding conducted by the management of so-and-so, culminating in the domestic inquiry report dated so-and-so. The learned labor court had lost sight of the position of law that it is only after it reaches its satisfaction to the effect that the domestic inquiry proceeding conducted by the management leading to the dismissal of the workmen were not valid or proper, it can assume
So
jurisdiction
take
to
your
proceed.
seat. Aram se, take your seat.
Assume jurisdiction to proceed deal with the evidence laid before it for adjudication of the industrial dispute referred to it by the reference. Thus, this court is of the unhesitant view that award dated so-and-so is not sustainable in law and same is liable to be set aside and quashed. It is accordingly set aside and quashed.
Have you raised the issue before the labor court?
It can be raised here also, Your Lordship.
No, that is another thing. I'm just
There
asking
is
whether,
no occasion for raising this issue before the trial court because
and according to you, the trial court has not discussed on the preliminary issue.
no
And-
discussion.
and
Even
but-
in this award also there is no discussion.
No, that's what I'm saying.
Yes,
The award is based only on the evidence laid before the labor court,
Before the labor court.
without looking into the domestic inquiry.
Exactly, because they, otherwise what happens?
So according to the before you looked into the evidence, first you have to decide. Labor court has to decide whether there is a illegality or perversity in the domestic inquiry.
Exactly.
As a preliminary issue, you will have to decide.
Definitely.
When you come to that, when you if the findings are to the effect that if it is if there's a perversity or whatever
Hmm.
in the domestic inquiry, then only you should proceed
Go, exactly, because
to
otherwise
take evidence, and on that basis you can decide.
so entire evidence which was given before the domestic inquiry will go in that event. Because otherwise there will be two evidence, one before the domestic inquiry and before the reference case.
Hmm.
So both cannot go together, Your Lordship. Like in the disciplinary proceeding. First, if the proceeding is correct, then definitely there is no question of discussing subsequently. If it is incorrect, if it is held incorrect, then definitely reference court will take up the evidence.
Hmm.
And in this case also same has happened, in the judgment which I have referred. So my humble submission before Your Lordship that this is a fit and proper case wherein this award should be set aside on this ground first. And with regard to the second chance which the judgment discussed, to that effect also I would like to place one judgment. Judgment. 2007 one SEC. 2007 one SEC. 2007. Okay. 448 এটা কি বলছেন? Paragraph 19 and 20, with regard to his previous conduct, behavior, all these things is not required to be considered. Because this judgment, this impugned order, judgment says that with regard to his previous, there is no such allegation. Paragraph 19, page 4. The learned single, you also got. The learned single just considered the past conduct of the delinquent employee as one of the ground in taking a lenient view. In our view, past conduct of workman is not relevant in departmental proceedings. Likewise, the learned single judge has erred in holding that workman did not involve in any misconduct of theft during the past services and on that ground granted reinstatement with the continuity of service. The learned judges of the High Court have also failed to appreciate that once an employee lost the confidence of the employer, it's very important, Lordship. It would not be safe and in the interest of the corporation to continue the employee in the service.
Is it the case of theft?
Yes. But anyway, he lost the confidence. So this is the case wherein your Lordship may kindly consider. And this, like in the judgment 2023 5 GL.
Evidence was laid before the labor court.
Even were laid before the labor court.
So he has relied on the labor court has relied on the evidence before
it.
Laid before.
Even in the award, if he had discussed with regard to the domestic inquiry, even then things would have been different. Even that was not discussed in the award also.
So according to you, the labor court is precluded from relying on the evidence laid before him until the time you decide that the domestic inquiry is frivolous or illegal.
Illegal. So in this case also, judgment which I have referred of this coordinate bench of this High Court, paragraph 28, while setting aside the award, matter was remanded back.
Which one?
This 23 5 GLT 850.
No, it's okay.
Similar incident, you know.
I try to find out the submission. I'm trying to understand your submission.
Yes.
Am I clear?
Yes.
What you are trying to submit?
Submit twofold submission, Your Lordship.
Huh.
First of all, Your Lordship, this preliminary issue was not framed and not decided by the labor court. So the finding of the labor court award, setting aside the award without looking into the domestic inquiry is perverse and illegal. First, my submission is there. And another submission, if we look at the award, evidence which was discussed before the labor
No,
court.
before that, according to you, unless you discussed and looked into the domestic inquiry, you cannot proceed.
Even if proceed, Your Lordship, even if proceed, suppose proceeded, then also in this award, my respectful submission and what I found from this judgment.
Not from the judgment. We'll come to the judgment later. Yes. Continue.
The labor court ought to have discussed in the award with regard to domestic inquiry. So when domestic inquiry is correct.
Therefore, you are not saying that unless you decide the preliminary, decides the domestic inquiry as a preliminary issue, they cannot proceed.
Yeah.
It's not your submission.
Yes, yes.
What you are saying is that first you have to discuss or decide about the domestic inquiry. Then only you can proceed. Even if you proceed to lead evidence, in the award you have to discuss or decide about the report or domestic of the domestic.
That is my submission.
You are not saying that unless it is discussed, you cannot proceed to lead evidence. I mean, decide the evidence before the court, labor court. You are not saying so.
No, I am saying both. This is my alternative argument, Your Lordship. That is why I have a twofold argument.
Hmm.
First, the preliminary issue. Court ought to have framed preliminary issue with regard to the domestic.
That's why you are not, are you saying that, are you submitting that unless you decide, you cannot rely on, you cannot proceed to take evidence, right? And rely on the evidence before the labor court. Are you saying so?
No, even if the evidence, your lordship, even if it takes up the evidence before the reference court, then also first preliminary issue ought to have been
See,
discussed.
reason is very simple. What I am asking is, why I'm saying so? Because labor court has an power to take evidence and can be relied on. At the same time, that evidence should not, I mean, while taking that evidence and relying on that evidence, they cannot lose sight of the fact, lose sight about the domestic inquiry.
Exactly.
The evidence in this domestic inquiry has to be looked into and discussed.
Definitely.
That is what I understand about
Yes,
it.
yes, your lordship. Yes, your
But it's not the case that until the time you decide or discuss with a finding of fault or illegality in the domestic inquiry, you cannot proceed to lead an evidence and decide the matter. It's not the case.
No,
That cannot be the law.
no, it cannot be. Even if it is proceeded,
Hmm.
there is no bar that
Even if it comes later,
later.
it's not the law. It cannot be a law
Hmm,
that without discussing first.
hmm.
Preliminary means what? Without discussing and deciding first about the domestic inquiry, you cannot proceed to lead an evidence and decide the matter. That cannot be a case.
That cannot.
It's the labor court has the power and authority to take evidence,
Evidence.
and rely on those evidence. Those evidence includes the domestic inquiry. Not separate from that, but obviously that will be connected with the domestic inquiry. All right. In this case, what you are trying to submit, if I correctly understood, is that though the labor court can proceed with the evidence and rely on the evidence, but first he has to discuss. It is required to be discussed about the domestic inquiry.
Exactly. your lordship.
This is what you are saying?
Yes, your lordship.
Yes.
Even if evidence is laid before the reference court,
Yes.
what court has to discuss, either preliminary or otherwise, it has to discuss in detail with regard to domestic inquiry.
Hmm.
Where is the fault in the domestic inquiry? And specifically, where is the wrong? Specifically, it is stated that whether there is fairness, whether there is a violation of natural justice or
No,
not.
it's not like a case that in the departmental proceedings,
Hmm.
under 226, we have a very limited scope.
Yes,
There is a very limited scope.
yes, your lordship.
All right. We cannot lead evidence. We cannot reappreciate. Is not it?
Yes. So labor court first arrive at a finding.
But then the labor code is stand different footing.
Fitting, but still,
The evidence can be laid there.
definitely.
Can rely on the evidence.
But there must be a finding with regard to the domestic inquiry report.
According to these judgments.
Yes, yes, lordship.
According to this judgment.
Yes.
Otherwise, this is nothing the written kind of thing that you
There
cannot
several-
proceed.
There is several judgment in the similar.
That's what I'm saying. Only basis of this judgment
Yes,
only
yes,
you are
yes.
saying. You are submitting.
Because otherwise what happens, lordship, there is two evidence. If domestic inquiry report is correct, suppose your lordship, and this says something different, contrary judgment is found, because both should be.
No, it's not a contrary judgment. See, when the evidence is laid before the labor court, it will have a bearing on those domestic inquiry only. The allegations, right? Their dismissal is under challenge. Therefore, the labor court has the power and authority to take evidence. On the basis of that evidence, merely because it has not been discussed, we cannot find fault in the decision of the award. I mean, the fine fault of the hour. Because it's not, you are deciding something separately.
Because there is.
Or on in isolation, you are not deciding.
Because there will be two decisions. One decision has already been taken. And Labour Court taking another decision.
Obviously, what's the wrong?
Whether the first decision, which was taken.
Against the departmental, or the
Domestic
management only, based on domestic inquiry and the departmental, management decision only, it is reference is before the Labour Court.
Of course, Your Lordship, definitely.
So Labour Court has the power and authority to rely on the evidence laid before him.
Of course, Your Lordship, I am not denying to that.
Then
they can look into the evidence.
It's not like the writ court sitting,
looking
into reappreciating the domestic, the disciplinary proceedings or the departmental proceedings. Labour Court has the power.
Labour Court has the power to take up the evidence.
The writ court doesn't have that power.
Your Lordship.
Writ court doesn't have that power.
Doesn't power.
There's a difference.
Right. I would like to impress upon Your Lordship that when there is again I am going to domestic report is also there.
Yes.
The domestic report after domestic.
Domestic, on the basis of domestic report, only the workman has been was terminated or dismissed. Now that is in place for under reference.
That is why under reference.
Then the Labour Court has the power and authority to take evidence and rely on that evidence. And obviously those the evidence and whatever is there, it will be connected with out of that domestic inquiry only.
Definitely. So that is why.
Not on the air, and it's not been picked up from somewhere else that you take evidence and decide.
No.
Therefore, unconnected. We cannot say that it is unconnected.
It is
and in isolation.
No, it cannot be isolation or unconnected. It is connected.
Yes.
Because domestic, that is why what I am submitting, the domestic inquiry, there must be a fault in the domestic inquiry report. Then only court will take the evidence. Obviously, this is the law what I am submitting. Domestic inquiry report is correct. There is no question of taking evidence. Domestic inquiry is correct if learned Labour Court found.
See, whether this is correct or not, you will have to have the evidence.
So that is already record is placed before the
you
Labour
have to
Court.
take the evidence.
Domestic inquiry report and all record were placed before the Labour Court.
That's what I'm saying. On that basis only they can take the evidence. Labour Court can take the evidence.
They can take the evidence.
Then,
but there must be.
It's not that you first. They must be finding this is something else.
Yes.
But then it's not that the Labour Court is barred from taking an evidence apart from the evidence taken in the domestic inquiry.
Evidence can be taken. I'm not.
That's what I'm saying.
Evidence can be taken. But while appreciating the entire thing, the learned Labour Court first decide that what is the wrong in the domestic inquiry report. While in deciding entirety.
Without that, there cannot be a trial or the evidence can be taken.
Evidence can be taken.
Then
evidence can be taken. But while considering the entire aspect, first learned Labour Court decide the issue.
That I have understood.
That is the issue.
No, indirectly, what you are trying to say, if I am correctly understood, that unless you decide whether this is wrong or right, unless you find it's wrong or illegal of the domestic inquiry, you cannot proceed.
It can proceed, Lordship.
Then
it can proceed, take evidence. I am not denying to that.
What you are saying is whether wrong or right, first you have to decide.
Yes,
if there is a wrong, then you will have to proceed. It's not the case. That cannot be.
No, I am not saying so, Your Lordship.
Then
what issue has to be, even if while deciding the entire.
What you are trying to say, I've understood. But then what I've understood, the simple, literal language of your submission, as if it's like, unless you decide that domestic inquiry is wrong, you cannot proceed with take evidence.
No.
Proceed with the trial.
I'm not submitting that.
Then-
while discussing entire thing by the labor court, while passing the final order,
They ought to have discussed.
discuss about the domestic inquiry report, what is the wrong, what, if there is any violation of the natural justice, everything has to be discussed. Simultaneously, it can discuss, your lordship. If it is found, then definitely there must be finding. This is what judgment says.
Then what about the evidence before the labor court?
No, even if it is labor court, that is why this judgment has said so.
I have seen, it's okay.
In this case, evidence was laid before the labor court,
Huh.
but preliminary issue or with regard to the domestic inquiry, there is no finding.
That I've understood.
Yeah.
So we've seen it, we will see it. But then issue was framed, which has been rightly framed. Whether the management of so is justified in dismissing the service of so and so. If not,
No,
is he entitled to reinstatement? It's this point of reference was there.
my
On this
opinion-
basis only evidence was taken. Where is the evidence? How many witnesses, how many evidences were taken?
before
Labor court.
labor court, I think. Four evidence. Four evidence.
By the management.
Management.
What about the workman?
Workmen perhaps one, I think. One, I think. Only this person.
What is the findings?
Finding,
Started, there's no material to show that page 100. Whether workman had filed any written so-called reply against Exhibit 4. Thereafter, a department inquiry proceedings were started against the workman. Is the notice issued to the workman informing on the inquiry? Copy of the inquiry report. Also proof documents such as intimation to general T by workman, so and so. Upon hearing. No direct question was to the workman, Mohan Gope. So this last judgment, we are in this page 102. There is no whisper that the workman Gope had any previous record repulsion on financial error.
yeah,
That is
previous record is not necessary.
strongly plead that the workman Gope admits his guilt. The man was first put open on the suspension. Interestingly, the value to so and so the workman. submitted the workman against charge sheet was received, therefore not action. No second chance was given to the workman to explain the charge thereafter. Second chance is required over us.
No, not required in lawsuit. That is why the judgment says so.
The workman only is now working somewhere for a living. Since a satellite management has to prove the effect of any engagement work after dismissal to deny. It is a settled law, the workman, the management has to prove the effect of any engagement work after dismissal to any and dismissal to deny backward since the that's all. Yes.
And this lenient view towards the workmen is not necessary. To that effect, Your Lordship, I would like to judge one another judgment.
So many judgment.
To show the generosity to the workmen.
You just compile and give it.
Your Lordship.
Just or else.
Okay. I will
No, it's okay. It's okay.
Oh.
You just give it. Compile. You just write it. Name of the judgment and citation, huh? You just compile. Huh?
Page paragraph 23 of the last judgment.
This is what?
2008 GLR, workman Sri Shibabari Tea Estate.
GLR.
GLR 2007 115 no 2000 GLR or GLR 2008 to GLR 85 para
33.
para 23. The decision on which Mr. Bhomigas placed reliance are all on the power of judicial review of the writ court to interfere with the penalty imposed by the workman on the workman by the management. There is no gainsaying that in a matter of awarding punishment on the proof charge, the scope of judicial review is very limited. Sympathy or generosity as a factor is impermissible. Loss of confidence is the primary factor. In my considered view, there are nothing wrong with the management losing the confidence or faith in the workmen and awarding the punishment or dismissal.
Relevant pair also you say. So and so naam likhi kini, then you write name of the party, then para. I marked it in pencil. Yes. Okay. That's all. Are you still working? Have you been reinstated?
Yes. No, not it.
Not Lord.
My Lord, before replying to his argument, I'd like to state the present status of this case. The workman has already attained retirement age. He crossed 60 years. And during this period, there are so many discussions going on between the management and the workmen regarding only the full and final settlement is pending. In regarding full and final settlement, the only dispute arises there, regarding his retirement age. The management want to give him full and final settlement on the age of 58 years, considering 58 years as retirement age. But according to workman, his retirement age should be 60 years. Because already management has granted 60 years of retirement age
to others.
So on that point only the settlement of full and final settlement is pending.
Otherwise, he is already settled. I mean, already retired. He has crossed 60 years.
Completed 60 years.
So what do we want now?
I want that actually I have not found
See,
any.
tomorrow, if we interfere with the award, better goes closed. Better ends there.
Actually, nothing remains in this case, my lord.
No, that's why I'm saying.
Question of interest is not there. Question of interest is not there.
Yes.
Because only the payment of full and final settlement.
Yes.
And that too, my lord, already he has received some amount. While admitting this case, my lord, this honorable court has directed the management to pay 30% of his back wages.
Under section 17B.
Not section 17B, my lord. As a whole, actually, this honorable court has directed, and already he received that 30% back wages. And 17B also he received till his
30% we had paid in view of the 17B application, Your Lordship.
Suspend until further order subject to petitioner complying with the provision section 17B of the industry and making payment 30%, yes.
Yes, in view of that order, we have paid.
They have complied with 17B also.
Yes, we have
Yes.
complied.
30% also you have.
30% in addition to the that 17B benefit, my lord.
Ah.
17B benefit with last on wages. Since the day of his termination, he received.
So
last-
what are you trying to say? Nothing is there.
My lord, actually, there is not. Only this 2 years, their dispute is whether 58 years retirement age or 60 years. And already the management has given 6 years benefit to all other his colleagues. To other colleagues. Now, they are telling that he will not.
Tug of war is 58 and 60 years.
Yes, my lord.
So what any
Age
information?
is 58, regular age of retirement is 58.
Yes.
Some of the employee, we extend their service considering various factors, Your Lordship, and that is our prerogative. We can continue for another 2 years, it is our prerogative.
No, in fact, since it's a workman and retired above 60 years, why don't you settle? Suppose tomorrow if you legally, even if you allow, will again remand it back to the labor court, unnecessarily they will not be able to pursue.
Anyway, 58 years is admitted, he has admitted the age of 58, he has admitted, Your Lordship. I can show document.
No, my admission does not arise, my lord. They have already implemented that provision.
No. On merit, we're hearing, I have heard him, I'll hear you, but what, since you have pointed out, what I'm saying for the interest of the workman,
Yes.
then nothing to, in fact, lose. The management has nothing much to lose.
We
It
had
is
already,
you.
we had been paying regular wage, the salary to the person till the attaining the age of 58, which is the superannuation.
Hmm.
Till that
Any
payment-
standing order about that?
Your Lordship,
Do you have the standing order about that?
regarding the payment,
No, retirement age of 58 years.
58 years, that we have, Your Lordship may kindly take up one IA we had filed, 1851.
No, well, if you agree, if you, if you dispute and you cannot settle, obviously we'll decide on merit. But I feel these are in view of the fact that, yes, mister,
Yes.
in view of your submission, I also feel that unnecessary why litigating all the time, future litigation and all that. Wait, what is this?
That Your Lordship will find,
Bring on record the dates and the past in yes.
Your Lordship in an application, affidavit that we had filed
Yes.
on 8/6/2022.
There is Annexa 3 of this
Page.
page 9. Like they
Page 9, Annex 3.
yes, they have what their condition regarding retirement age, my lord. You will also kindly see. Medical fitness.
Just wait.
Page 9.
Interrogative application.
Yes, this was filed on 8/6/2022.
There is only page 9.
Page 9. Type copy of the order. Will you got it?
No, this is interlocutory.
Integrally,
There is an
1851. 1851.
Yes.
IA 1851.
Yes.
There we have filed one affidavit,
Yes.
which was filed on 8/6/2022.
In IA, you have filed an affidavit. Again, affidavit. What sort of affidavit? By whom?
It was by me.
body management.
In IA,
IA
affidavit filed on
8/6/2022 by the management.
affidavit in opposition on behalf of respondent number 1 against. reply. So many reply.
8/6/2023, Lordship got it. Affidavit in reply.
Reply again.
Affidavit in reply. 8/6/2022.
I have petition number 1851.
Affidavit in reply.
Of the applicant to the affidavit in opposition filed by the opposite party number 1. 8/6/2022. It was filed on 8/6/2020.
Yes.
That you will finally come to page 9. This is the type copy of the.
In this regard, we would like to inform you that our member T states were advised to extend the
Advised to
term
extend
as
the
from
retirement
48
age
to
to
60,
subject to
three
three basic conditions as follows.
medical presence certified company, no proven criminal misconduct, unblemished service record free from.
Lordship,
This is
got
by
it?
whom?
This is a general letter. So it is
The
advised.
Association of India.
This is an advisory. We may not. If we continue, then we take these three conditions.
Retirement age from 58 to 60 years.
Yeah.
It
It is-
appears to be 58,
Uh,
but this is by the Labor Secretary, Labor Advisor
That is why
from the Tea Association of India
this is
to
the.
raise the extend 58 to 60 years.
Yes, they have extended to 60 years, my lord.
Where it is?
They have already, they are giving 60 years benefit to other water.
Where it is?
It is there, it is admitted fact, my lord.
It's not admitted. You see, page 9.
Yes, page 9, there are three conditions, my lord. There.
Forget about the condition. We would like to inform you that our member T states were advised to extend the retirement age from 58 to 60 years, subject to three basic conditions as below.
Yes.
That means when you are advising, suggesting to extend the age from 58 to 60 years on these three conditions,
Yes, my lord.
so it's up to the management.
That is why.
That means it indicates that the age, retirement age is 50 years, right?
Yes, my lord. That they have, the management has accepted this condition. This,
Where it is?
they have already implemented, my lord.
Where it is?
That I cannot show, my lord.
You have to show. When you are saying, you have to show, sir.
Your Lordship may kindly come to page 11, Your Lordship. Kindly page 11.
Sir, we were trying to understand and so that the matter can be resolved, right? It's not typically, I mean, kind of
They are giving.
page 11.
Page 11. This is the meeting held
With management of Dumiti State, their workmen Sri Mohan Gopi in pursuance of Sri Richard.
labor officer, is the government officer, labor officer. This was
The matter relates to case number so and so pending what the High Court was not touched upon by the member. However, after a thorough and peaceful, the following points were agreed upon by both the management and workmen. Pending ration and tea leaves will be paid from 1st August 2020 in the periodic installment, keeping in view the available ration of the replacement as a daily rated worker and in practice preferably will be provided to his son after his pending TA bills amounting to 10,000 will be paid at the time of a gratuity will be paid on or before 15 and he will vacate this term. Retirement as a 50 years accepted or 60 years is not as per
so
now.
50
Yes.
has been accepted, Your Lordship. He has accepted it.
No, no.
And replacement is also there as daily rate one factory will be provided in this way. Has your son been replaced?
After this also, the management.
Has your son has been replaced?
My lord?
Has your son has been given as a daily rated worker?
No.
We are ready. They are not coming forward. We are ready, Your Lord.
They have not complied with this, with these decisions, my lord. This agreement was made, this so-called agreement. This agreement was also not implemented by the management.
We are ready to implement. They are not
They have
coming
not-
forward.
They have not, within 15 September, they should have offered him the gratuity, etc.
Let us not go into technically. Since you have raised this thing, I'm not saying that we are not hearing you. If you are ready to accept this, go for this settlement. It's already decision has been taken.
We are
Instead of
ready.
going into the merit of the matter,
Yes, that
It's better because you're this,
The workman.
that's why I'm asking, sir.
The workman.
Have
was
you son, has your son been, replaced as daily rated worker?
No, no, I am not interested, God.
It is,
I'm
If
not
you are not interested and you want that assessment, you are saying that it has not been implemented.
Yes, miss. They have not the gratuity, but 15 September 21, they agreed to pay. But they have not even called the workman to receive that gratuity.
so we're all along ready. Even today, if he says that he's ready to, we're ready.
See, for the better or well-being of your client only, I'm just asking whether you are interested to go for this settlement.
Yes, I'm going for the settlement, provided the retirement age is.
No,
considered
that
as
cannot
50.
be, because retirement age of 50 years is accepted by workmen, age 60 years is not as per norms.
It is written there, my lord.
Huh?
It is written there, but the workman never accepted it.
You have signed this.
That was signed, he signed. He signed, yes.
Sir, you are not, I think you don't have a instruction. Take proper instruction. See, after the retirement, definitely if he doesn't agree, I have heard him, I'll hear you and pass the order. We'll decide the matter. But my anxiety, this court wants that why unnecessary go for litigation again and again. Suppose if we interfere also, we'll send it back to the labor court. Another 5 years.
There will be no use, my lord.
Huh?
There will be no use.
That's what I'm saying. That's why I'm saying, sir, if you agree this in these terms which you have already accepted, Mohan Gope, your signature is there, page 11. You settle and have a, enjoy your, have a better, enjoy your evening of your life. You get all these benefits, whatever you want. As it has been already settled before this thing, labor officer, who is the welfare officer, is not it?
Yes, labor government officer is also there. We are ready to comply with this, but this is this wonderful problem, difficulty is that they are not coming to us.
See, I believe in, I believe in, instead of, lengthy, the proceedings and the nitty-gritty of this, legal technically,
25.
if a
to
person
25.
get a,
This agreement was.
if
made
a
in
person get,
2021.
if a litigant can get a instant justice is better.
Yes, my lord. My only objection is that the management has delayed this matter for 4 years, my lord.
It's all right.
if-
It's not a
if-
question of delay, it's a matter of procedure. That's why I'm saying, another 5 years, another 10 years, who knows? This is procedural hazards which all of us has to be blamed. Lawyers, judges, and all these things.
Yes.
I frankly admit, this delay, we're trying our best. That's why we need your support. We need to have a better case management.
It
Why
would have-
delay?
It would have finished.
Why delay?
Delay is due to management, my lord.
Not only management.
He is not accepting this
No,
now.
no, no, my
The
lord.
litigants are not delaying, right? It is us
I told
who
him.
got
I
it delayed.
personally told him.
I'm not saying you. I'm saying purposefully, it is us who got it delayed, not the litigants. That's why I believe in instant justice.
That's true, my lord. If this agreement was made in 2021, if they would have implemented it, and it would have finished that.
It's not a case I'm hearing. What I'm trying to tell you is, for the well-being or betterment of your litigant, workman, you finish it off. Otherwise, I've heard him. I'll hear you and pass the order. That's all.
Yes, my lord.
What do you say?
No, I have lot of argument against this submission, my lord. But I am not interested for that. Because already workman is suffering. And it is already delayed, my lord.
That's
Let-
why I'm saying. That's
let-
why I'm suggesting. What is to be done?
Let the full and final settlement be made within immediate.
As per this, as per this decision, page 11.
Yes,
We are ready here.
yes, Milord.
Or else you take instruction. You
No,
take,
Milord, no.
no, tomorrow they may say otherwise. Have you taken the consent from that thing? In that case, we will not go into the merit.
Milord, for money, Milord, nobody is satisfied, Milord.
Huh?
So for money is, sir, because if I am go to take instruction, he'll say that some up to 2 years benefit. So.
No, it's not that. See, it's not that. It's not a question. That is not what what I am asking. If you want to have a settlement, you cannot do it your own.
Yes.
You should have a instruction, right? Your litigant has to agree to that. It's not a discretion of the lawyer, right?
Whereas my learned friend has already instruction.
If you have an instruction, we'll pass the order as you agreed.
Okay, later they will fix, I shall take.
No. If you want to take instruction, we'll give you by tomorrow.
It's a very long distance. Milord. So,
Do you have the instruction that will settle on this as per the minutes which you have drawn, where you have put your signature? Because it refers to the writ petition also. The committee, I mean the decision, it clearly says, you read it.
Yes, yes.
They have not touched the issue of the writ petition, pending writ petition.
Yes, yes.
But then, so far as the retirement is, so far the payment, gratuity, something, and the replacement, they have decided that we'll go for this. If it is not implemented, we'll say that in view of this decision and all, as agreed to by the parties, the management will immediately implement it. Within 3 weeks, you implement it,
If that direction
give the
comes-
benefits, the entitlements as per decision of these minutes to the workmen. We'll say so. All right.
that can be said.
If you agree, we'll pass that order.
Yes, I am.
We are going into the merit. Although we have spent, considerable time on it.
It's already delayed, this matter is already delayed, but I don't want any further delay.
Sir, are you getting me what I'm trying to convey?
Yes,
Are you getting me what this court trying to convey to you?
yes, ma'am.
Convey to you in the sense it's the interest of the litigant. I mean, the workman,
Workman.
respondent number 1. So we'll go by that in that case. All right?
Yes.
Yes. We'll say it's a consent order to implement the decision taken on so and so. Therefore, within 3 weeks, you comply with that. Therefore, the writ petition stands closed in view of that being infructuous, being not pressed, we'll say, being not pressed in view of the agreement. Page 11.
Page 11.
All right. Heard Mr.
N. Sharma.
N. Sharma, learned counsel for the petitioner. And also heard Mr.
As thus,
Huh?
as thus.
S. Das, learned counsel for the respondent number 1. Presiding officer, why he should be nominee? He's made party. Why the presiding officer should be made party?
No, Milord, court should not be made party, Milord. This is the reason of.
Actually,
Anyway, this
government.
next para. Writ petition has been prepared. Assailing the prepared by the petitioner, namely, management, Dumni Tea Estate, huh? Assailing the where is the award?
About page,
95,
page 90,
85.
page 95,
It's a 95, huh?
page 95.
Award dated 22/05/2017. Passed by the Labor Court, Assam at Guwahati, whereby the dismissal of the respondent number 1 public workman has been interfered with a direction to pay back wages from the date of dismissal till reinstatement. List of the this court, while issuing notice this court by the order dated 12/09/2017, while issuing notice has suspended the award passed by the Labor Court. No, award dated 22/05/2017, passed by the Labor Court, Kamrup, Guwahati, in reference case number 2 of 2016. You just mentioned that award passed in so and so by the so and so in initial against assailing the reference case number. Subject to complying with the provision of Section 17B of the Industrial Disputes Act 1947 and making payment of 30% of the back wages to the workmen. Listen. Next para. After hearing the parties at some length, the learned counsel for the parties have come to an agreement on instruction that in view of the where is that page? In view of the
Page 11.
minutes of the meeting held on 21/07/2021 between the management of Dumni Tea Estate and their workmen, sorry, between the petitioner and the respondent number 1, namely Sri Mohan Gope, in the presence of the labor officer, Cockreger, the parties are ready to settle the matter as per the decision, as per the decision of the minutes of the meeting. But is ready to settle the matter, Settle the matter. Mr. Next para. Having considered that parties have decided to settle the matter as per the minutes of the meeting, without going into the merit of the matter, I am of the considered view that for the best interest of the parties, it would be appropriate to close this writ petition. List of the minutes of the meeting is referred is repeat this hearing and for ready reference, huh? Page 11, huh? In the this thing. Next parent, as agreed to by the parties, the management, the petitioner, i.e. management, the Domiti state, huh? Shall implement the decisions as taken, as referred to above within a period of 3 weeks. 3 weeks from today.
Yes.
We'll make it 3 weeks from today. Mr. It is expected that no further. It is expected that the petitioner the management of Dumi Tea Estate shall settle the matter as agreed herein above without within the period as directed herein above, without putting any hardship to the workman.
And he will also cooperate with us.
List of. At the same time, the workman, respondent number 1, the workman shall cooperate with the management for settlement as agreed to by, for settlement in terms of the minutes of the meeting dated 21/7/2021. That's all.
In view of that, the award goes in office.
In view of the settlement between the parties, the award.
Matter become interest also.
We'll say the
Interest also.
no, we'll say the award goes award stands interfered with. Award stand interfered with. And no, we'll say it has to go.
Has to go, definitely.
Award has to go.
This matter become interest also. The issue become interest.
In view of the settlement, the award is set aside, of course. It cannot be given.
We'll say in view of the writ petition stand disposed of as infructuous. As infructuous.
Interest
What about the award LOC? What about the award LOC?
The award is already you have implemented.
No, there must be some finding to the award LOC.
Award is that agreement itself shows that you have going to.
No, you are not going to implement the award again.
Definitely.
They have made
Okay,
the
the
agreement in terms of the award actually.
award goes.
Hmm.
Award goes.
Mm.
All right.
Mm.
We are not going to get it implemented.
Hmm.
Huh?
As per these terms, the agreement, they have implemented the award.
Huh?
They have implemented the award. They have admitted the award. The only dispute was regarding retirement age.
No, award is not implemented. Award is full back wages. You have been given 30% as of now, right? 30% as of now you have received. 30% of
30%, Milord. We have after 17B last done.
as per the award will not go. Okay.
To be satisfied.
Sir, let us not make it complicated. Once you have settled the matter.
Yes, yes.
All right?
That has to.
Huh? Teacher has to be sent back. Huh? Send back the teacher and IA also, in view of the order passed in WPC, IA stands closed. Mr. Das not happy.
Deeply obliged, Your Lordship.
Obliged.
Raj Mahal.
Rajmahal.
My lord, I have been, my lord, illegally terminated.
My lord, it is
From-
my pen to.
So,
From the
being a bellboy.
service, yes,
So,
in the year 2009, my lord.
so, where are you
Thereafter-
now?
Thereafter, my lord, they filed writ petition challenging the award. The matter remanded back to the, my lord, presiding officer, Labor Court.
Yes.
Matter was further, my lord, heard. The basis of the materials on record. The learned Labor Court, my lord, after hearing the parties and or perusal of the materials on record, once again has held, my lord, that the termination is illegal. Therefore, my lord, I am entitled to, my lord, reinstated in my service as I was, and my lord, with back wages. Thereafter, again, my lord, they have filed this present writ petition. This is second round of litigation. And this writ petition is pending for, my lord, since long. Your lordship will from 2018, my lord.
Yes.
Now, my lord, I am, my lord, unemployed. I did not get any, my lord, service
employed?
related- No, I am not, my lord.
You are employed, you are not employed anywhere.
Nowhere.
Okay.
Because I am expecting that I'll get my lord, back wages, with reinstatement with back wages and this and that. Therefore, my lord, now this is, my lord, all about, my lord, 12 years, decade, my lord. The litigation is pending, my lord. Now, my lord, I am living on the charity of my friends, well-wishers and relatives, my lord, because I'm not getting my salary since 2000. Now, my learned friend, my lord, has proposed, my lord, of course, this is, my lord, of the report I am submitting, my lord, that the management is ready to pay a sum of rupees 1 lakh, my lord. Now, that is, of course, my lord, I'll need to take instruction from my client, my lord. But my client,
Why you are not employed for last 10 years, 12 years? It's a bail boy.
my lord, because
You
there
could have
was-
looked for a greener pasture,
My lord, there was,
better opportunities.
my lord, there was help.
It's okay. What do you want today? If you want sometime, we'll grant you today to take instruction.
Matter may be referred because the mediation is going on, my lord, national mediation.
We can decide what's there.
Your lordship may refer it to mediation, my lord, subject to my learned friends.
I have no objection.
Has it been, can we?
Let us explore it, my lord, instead of, my lord, fighting each other. My
Can
lord,
it be
for
referred?
years
Can it be
together.
referred?
Yes, my lord, it can be.
If you agree, we'll refer, we'll say the, as agreed to by the parties, let this matter be placed before the mediation. National, what is it called? It is not an identified matter.
It is not identified.
We're supposed to identify the certain matters.
Matters, but money related matters.
Ah.
This is also a case of, my lord, payment of
Employment,
wages.
service can also be in
Yes.
certain cases.
Service
If you
can-
agree, we can refer it.
Yes.
Because unnecessary, again, it's a, I
Yes,
think,
my lord.
again,
Yes.
if we find that, again, referred back to, remand back to labor code, again, unnecessary.
Again, my lord,
Okay.
2 years, 3 years, 5 years, you do not
Ah.
know, my lord.
What do we call it? That,
Most probably the bench will go to
nation-
copy,
Ah.
the exact name.
Let me check it minute. I am have a copy, I
Ah.
am having a copy.
no, we have referred so many. And
Yes.
from in eternal bench also, we have referred so many.
Yes,
It has to be first identified by the registry. Then it is listed before the court. Then we referred it and subject to, I mean, agreement by the parties. We
My,
can
my
refer it.
learned senior friend is otherwise agreeable, my lord.
Yeah.
Therefore, it can be referred, my lord.
Ah.
My lord, this is called, my lord, referral to the special mediation drive for the nation.
Ah. Then we'll say, heard Mr. O.P. Bhatti, learned counsel for the petitioner, and Mr. B.K. Sen,
My lord.
learned counsel for the respondent. Respondent number one, right?
Yes, my lord, sole response.
Sole respondent. As agreed to by the learned counsel for the parties, next pair, huh? And considering the matters, I mean, considering the matter involved in this writ petition being relates to, pertains to workmen, comma, let this matter be placed before the, you just give that mediation something, huh? So and so, so and so. Do we need to appoint mediator?
No, it is already there.
Mediator
It's
is
already there,
Yeah.
the lordship has just.
Then in, you see, in
written.
eternal bench, we have here also we have for this we have separate mediators.
Yes, my lord.
If you have a choice of mediator,
No, mediator.
or we
sentence
can
is there.
appoint,
My lord,
so that they can give the report.
yes. Register may be directed to refer the matter to the mediator.
No, that I have already passed, but in this particular, I mean, special this thing,
There is
No.
no such, my lord.
mediation, no, procedure is
Yes.
either you choose the mediator or court will appoint.
Court
Court
will
will
appoint.
You give the list of that name, you appoint one, Sri so and so, learned mediator. You take it from the panel, huh? There's a list of mediators for this purpose. Huh? No. Procedure is we appoint them because they need to give a report and we'll fix the matter after 2 weeks.
Yes, by this.
You just
time,
take out one this thing. Name of just keep it blank. The Mr. So and so, learned counsel, learned mediator is, learned counsel so and so is appointed as mediator. Then you write the learned counsel for the parties to
appear.
No, not appear. Learned counsel for the parties to furnish the copy of the relevant papers to the learned mediator, list of the mediator to place the report after 3 weeks. We'll intimate, we'll let you know the name of the mediator. You furnish this
Yeah,
papers only,
Copies of the pleadings.
readings.
Right.
And the matter will be listed after 3 weeks. In the meantime, because it should be placed, that will be mediated. The mediator will take or registry will take a call when to be called, when to be
Yes.
taken, I mean, matter will be taken up. Then they'll furnish a report,
Copy, report, yes.
report of the mediation. Then we'll close down if agreed. That's the system. So we're appointing one from mediator from the panel of mediators.
So the report will disclose that whether the matter is resolved.
Yes, yes, definitely. After the
Definitely.
mediation, he'll mediate, and then after that only he'll furnish. If it is resolved, we'll close the matter as per the settlement or the mediation.
If not, your lordship will have.
We'll have to hear it. There's the
That's the
system.
procedure.
So you will be intimated by tomorrow who has been appointed. Kindly take the report from there.
Yes. By the court master, my lord.
Yes. Who is appointed? Because you have to furnish the pleadings
Yes.
to the mediator. All right?
I take the number, my lord. Phone
Ha,
number, mobile.
Yes, yes.
Deeply obliged, my lord.
No, for respondent number 2, I will be appearing, Lord.
Okay.
Respondent number.
Our Talukdar. Ha.
State of Assam.
We'll take it up. Let's see. Yes.
My lord, I am deeply obliged.
Yes.
Not
Yes.
true.
Yes.
Lord, SSA was directed to take the instruction, my lord.
Where is Mr. P9?
I told one of our colleague to inform him, I don't know, inform, I think he's on lakes, my lord. Some other port.
He's on lake.
I think, my lord, because,
We'll take it up at 2.
at 2, my lord,
Huh?
at 2.
Somehow,
my lord, we didn't notice that my lord had come.
No,
Extremely
sir,
sorry.
I was enjoying from inside chamber also. Your discussion.
The IA, my lord, is nothing. My lord, so far as 93 rule 1 is concerned, I will not press for it at this stage because my learned friend has an objection. But so far as my lord, rule 2 is concerned, in any case, these are public documents. But unfortunately, Election Commission is also very, very careful. Unless and until there is an observation from this court, they
This-
would not allow us to.
No, IA 212 is for what?
My lord, IA 212, my lord, we wanted to have a look into all those very materials which they have already accessed, only for that purpose. But since, my lord, so far as Rule 93, Sub-Rule 1 is concerned, without the order of the Honorable Court, we cannot inspect. Since they have an objection on Rule 93, Sub-Rule 1, I will not make a prayer for that part at this stage. It is all subject to the nature of evidence that comes in their affidavit. My lord, that stage, as and when it comes, my lord, then we will take a call.
So
So at this stage, I'm not making that prayer.
okay.
Only
We'll just keep
part
it.
2.
We'll keep it pending.
My lord, no, only part 2, lordship may allow us the liberty to make a prayer to commission because it's a public document. Anybody can have access to that.
Part 2, I think, is only the videography, my lord, which that.
You have only looked into it, my lord. But anyway, that their IA 54 was there. My lord had passed an order in IA 54. So whatever things have been mentioned in IA 54, that lordship's order at page 26, operative beginning, the operative portion, my lord, will find at page page 47, last page, para 44. That is 1, 2, 3, 4th line, particularly D, E, F, H, I, J, K, L, Q, and U. These are all covered by Rule 93, Sub-Rule 2, public documents. So, my lord, that, my lord, we may inspect if it is necessary, relevant, we feel, then, my lord, in that case, we will obtain the copy. That is all.
Well, as far as D, E, F, G, these are, I will just cross check, these are all videography. As far as the videography is concerned, that is, they are entitled to anybody is entitled to from the public on payment of fees.
That is it, but since in your case too, they had a
But
problem.
if there is any other document, Miller, what is D here? Exactly.
They too is covered by Rule 2. Covered by Rule 2. Even the Honorable Court had made it very clear.
Just
It's all covered by Rule 2.
Have you not particularly mentioned those documents?
My lord, I have not mentioned. I only said, my lord, my prayer is, I have referred to the orders of my lord in the prayer one, passed in IA 182 of 2025 and 54 of 2025. Since lord in 182 of 2025, my lord allowed them to inspect the documents covered by Rule 93, Sub Rule 1. But in IA 54 of 2025, my lord referred to everything and declined their prayer covered by Rule 93, Sub Rule 1. Those very documents my lord mentioned in para 44. At the same time, lordship allowed them to obtain copies of other documents which have been mentioned, my lord, in para 44 at page 47, which are covered by Sub Rule 2. Only that much, my lord. That we will look into. My lord, it is only at this stage I am not pressing for Rule 93, Sub Rule 1 prayer. At this stage, I am not making a, I'm not pressing it.
Then we close this IA?
Yes, lordship will close it with that observation. That in any case, my lord, I can always
Will allow him
For the,
as we have allowed you.
not for the Rule 193 1, my lord.
I'm not pressing for it.
Only for the subsequent,
Yes,
93
yes,
2.
Yes.
That is mostly videographs, my lord, and the handbook of the presiding officer.
Para 44.
We'll see.
My lord, direction in para 44.
We'll just say that the documents as mentioned in the order dated so and so
Yes.
may be allowed to be inspected.
In para 44, such and such
We'll
document.
just refer.
Right.
Heard, Mr. That's all.
That's all. That's all.
Not the entire document, my lord. Only para 44. This,
Yes, this DEFHI as allowed, I will say as allowed to the petitioner.
Right.
Heard Mr. PKT and senior counsel assisted by Mr. Learned counsel for the applicant public election petition respondent. And also heard Mr. Rituras, which was learned counsel for opposite party public respondent election petitioner. By filing is this application under Rule 93 of the Conduct of Rules, Conduct of Election Rules 1961. The applicant has read for allow him to inspect only inspection.
If necessary, we may even obtain copies by payment of fees. That rule permits.
Inspect and obtain copies thereof is allowed to the opposite party of the election petition to those documents as mentioned in the order dated. What is this order? 1905.
Yes.
19/5/05/2025 in IA 54 of 2025. List of having heard it and consent to learned senior consent and prayer not being objected to by the learned counsel for the opposite party of the election petitioner. I deem it appropriate to allow the applicant, the respondent, to inspect and obtain copies thereof to those documents, material, documents, materials.
Yes. Whatever.
As mentioned, as D,EFH, page 47, IJKL, in accordance with the rules, as the same are covered by Rule 93(2) within bracket A, bracket close, and B of the Conduct of Election Rules 1961. That's all.
That's all. Not only not one caution, because lest the principle of constructive res judicata comes into play. At this stage, I am not making a prayer for sub rule 1, Rule 93. So in future, if situation arises, I may again approach the honorable court.
Will not
So
say,
those
will
will
not
be
say
kept open.
anything. I think
Let them be
there would not be a bar.
Those documents will be before your lordship.
Yes.
when I-
Yes, in any case, we know that, but just
The
But always-
next pair. The IA stands allowed and disposed of.
My lord, in the main matter.
Let us proceed, the main matter.
In the main matter, my lord, my lord, after your lordship's direction, my lord, we are in the process of inspecting those documents.
Ah,
The records are quite voluminous, my lord. I need at least 3-4 weeks time, my lord, to file my evidence.
after, but
Right, objective.
I would request, let us proceed.
Very well.
I think, I believe almost all this
because thereafter,
It's-
so an affidavit has to.
IA should be over now.
Well, I
Yes,
can
no,
assure,
yes.
I can assure the.
At least before this court.
I can.
You may approach the, higher court, there's no.
No,
they
I can
cannot-
assure my lord that now, my lord, IA will not come at least till the stage of evidence on affidavit.
Yes.
So, my lord, 4 weeks time for the petitioner
Hmm.
for filing our evidence. Affidavit. of
Okay.
evidence. Ah.
In main case, huh? Heard Mr. Rituraj, huh? And DJ Kapil is learned counsel for the election petitioner. And also had Mr. PKT learned assisted by Ms. So same, huh? Should I say that let the matter be fixed after 4 weeks for filing of evidence?
Evidence on affidavit by the election
Evidence-
petitioner.
Filing of evidence on affidavit, huh?
That is by election petitioner.
Matter be fixed after 4 weeks, any particular date. Let us better to fix the date.
Yes. Sir, बोलिए.
After 4 weeks,
September. Puja is from 26 September. Then, my lord, it will be in October only because puja begins
before,
from
before
26
let us try before one.
So, my lord, maybe 25th or 26th of September, just before the vacation.
Let it be 26.
26th. Yeah.
Let me see, huh? On so and so. For filing of affidavit of evidence. Affidavit in? Evidence.
By election petitioner.
Evidence in affidavit by election petitioner.
My
That's
lord,
all.
again, my lord, my apologies for
Yes.
faux pas when my lord entered the courtroom.
No, that's all.
Sorry.
So, what do I say? Before you say that. Need a photo. Yes, sir.
This is the preliminary instruction I received. Meeting was like first time, process time. Mr. Petitioner was first time. Last 2 years. There was next 2 years of participation. Agreed decision, association. Lordship, most important is the point number 4, Lordship.
Yes.
Lordship, a meeting took place on 25/7/2025, Lordship. It was called by the Minister of the Department, Lordship. Wherein, Lordship, along with the departmental officers, all the, the persons who signed in the attendance sheet, Lordship, that is annexure 1, were present in that meeting, Lordship.
Yes.
4 of the writ petitioners were also personally present. And in that meeting, a decision was taken that those who supplied substandard material in the last 2 years,
they shall not be allowed to participate in the tender in the coming 2 years, Lordship. So that was the decision taken.
No, that is, sir, that is the whole problem. There's no issue. There's no problem. That is what you, but then the problem is here is it amounts to blacklisting without notice.
No, they were, that is what I'm
It's
saying.
okay, but
They
then-
were present in that meeting.
So
Lordship.
it's not that once they are allowed, you may reject on that ground also.
No, that is.
They should be allowed to participate.
Yes, that is one reason.
You
Lordship.
may, I'm not, I mean, I'm not advising you,
Yes,
suggesting you.
no.
That could be a ground also, rejection also,
Lordship,
because when you, I mean, have that quotation and NIT, you have to examine from whom to get it.
Yes, that is one aspect.
You
Lordship.
have a
But
scope
Lordship,
there.
if Lordship, in spite of knowing fully well that these are the persons who.
No,
supplied substandard material.
this amounts to, in my prima facie view,
Yes.
this court's premise amounts to, I mean, blacklisting
moreover,
without
Lordship-
any proceedings.
Lordship, moreover, Lordship, in the meeting when this.
Minimum and notice has to be given because they candidly
Yes,
admitted.
I admit. that-
They are also admitting that there are certain, I mean, substandard materials were there, but it was rectified.
Yeah.
But these are the grounds
That
you
is
may.
one aspect, Lordship. But
Today, this time, today,
and the most important aspect, Lordship,
huh.
there are around 36,778 schools.
Hmm.
And tenders were notified by the respective SMCs of those schools, Lordship, not by the SSC. This is a decentralized process, Lordship.
So we'll allow them wherever they can. We'll just
Yes.
say that we'll not say, we'll not mentioning any thing. Since the tender, the NIT or the quotation is under process, has not been completed. In maximum,
But in some
in some of these schools,
So as per the guidance.
they may be allowed to participate.
If Lordship comes to.
Manually.
Annexure 2, Lordship.
Yes, that is,
One Annexure 2 is there, Lordship.
no, wherever it's over, you cannot help it out. We
Lordship.
said wherever it's not over, they should be allowed to participate manually, right?
No, my only concern is that Lordship order should not be given any meaning that by allowing them to participate in the tender process,
Yes.
in the subsequent stage, we have lost the opportunity of rejecting them in participating.
We're
I
not
mean,
saying anything.
that
Only
Lordship-
we are allowing to participate them by way of manually.
No,
Because
tender-
now it will be difficult to register them because you have already decided. That's the whole problem.
Lordship.
Subject to further order, we'll say. Subject to further order in the meantime, we'll just say.
Lordship.
And it doesn't mean that if the moment they participate, they should be given. It's not that. There's a committee
Yeah.
to examine. I'll not say much
Otherwise, Lordship,
because I feel because no proceedings has been initiated for blacklisting, at least to so cause.
no, at least
Should have been.
Lordship, they were not blacklisted, but a decision is there. What's the pending?
No, it amounts to
A
blacklisting.
decision is there, Lordship, not allowing them to participate in the next 2 years round, Lordship.
No, that will not be. That will not be possible. It's as good as blacklisting.
And Lordship is, they.
Blacklisting is for what?
Lordship,
1 year,
2
2 years, 3
At
years.
least 4 petitioners are there who are aware about this decision, but they suppress this fact, Lordship.
We'll say,
Yes, okay.
you file a detailed affidavit because time is running out, so therefore we'll allow them manually to participate in the tender, NIT, oblique quotation,
Yes.
wherever wherever the schools have not completed their process.
I mean, the bid process where is not.
Wherever the
Last date is not yet over.
ah.
Last date is not.
Therefore, that's the
where is
reason.
first quotation?
Wherever it is over, they cannot, obviously. Suppose we have seen, for
Yes,
example,
correct.
here.
In one school, my lord, yesterday.
already
was
over.
last date, my lord.
As I have stated, Lordship, there are around 40,000 schools. All of them will float their own individual.
Yes.
NIT, Lordship.
No, they will follow that. It's not that they'll just go to you.
Yes, Lord.
Wherever it is, they'll apply, they will be allowed to participate through manually, we'll say. Because registration is not possible. Because you have already decided that they should not be allowed to register. That's why it's been declined or something like that.
Yes, ma'am. That page
Ineligible or declined.
53 page, ma'am. Page 53 last. column, only those vendors. Page
No, no, not that, which, where you have applied. Invalid,
Yes, yes, page 62 in value.
invalid, 62.
On this ground, my lord, our tender may not be cancelled.
Huh?
On this ground, my lord, if we submit manually.
No, for a timing, we'll just allow you to participate
Yes, my lord.
in the schools wherever it's not, the last date is not over.
That is my apprehension
Yes.
actually.
Hmm.
Lordship is allowing them, they will participate, but that should not be a ground for them, for us to reject their, or to allow them to supply the materials also. That should not be a ground. for-
No, we're just allowing them to participate,
Yes.
subject to further order.
In spite of
We're
that,
putting that
I-
also.
My only reservation is that, Lordship.
See, they will
Lordship is
allow
now aware that these are the persons, Lordship, who supplied substandard material.
you,
And these are the beneficiaries will be also the students.
Been served with a so-called notice, my lord, which the.
no, that is the whole point where I'm inclined to grant you a interim order.
Yes,
But finally we'll decide.
yes, friends.
Granting, rejecting after the participant, it's your discretion.
Yeah.
Of course,
That-
within
that
the four,
That's one observation only. Lordship.
no, that will not say anything.
Lordship, otherwise, Lordship, in subsequent.
Participation doesn't mean what's the use of calling quotation and NIT? I mean, no. What is the question? I mean, what is the meaning of having a NIT?
No.
You will
now,
have to
Lordship,
evaluate.
No, Lordship, one thing Lordship will take note of.
Huh.
Till now, they have failed to project against which NIT they are intending to participate.
We'll say wherever they are.
As per the guideline, we are entitled to participate in the quotation as well as the tendering process, my lord. This is their
That-
own
I think
document,
They
my
have
lord.
failed, Lordship. Out of
How
this,
I can fail, my
out
lord?
of this
The NIT
36,000.
NIT
Against
is my
which
lord on
Sir,
particular
let us
September, my
not
lord.
complicate. We'll allow them
Yes,
to
my lord.
participate manually. It's just a quotation. What is the amount of the tender?
Tender process is
To
manual.
1 lakh, it is quotation, and 1 lakh to 20 lakhs is open tender. Lordships can find it page 53.
It's okay. It's okay. These are for how many? Amount
It
is
is
how
not
much?
entire Assam, my lord. Lordship will at page 49. Kindly go through my lord. Page 49, the first bold letters, my lord.
Huh.
Government, the guideline for procurement of free school uniforms are to be provided to all children from class 2-8 of government provincialized LP, UP composite schools. And thereafter, my lord, the first paragraph, Government of Assam has decided to provide 2 pairs of free uniforms to all students of class 1 to 8 of government provincialized so-and-so school for the year 25-26 to be used for the academic year 26-27. Under Samogra Hikha for this purpose, following the guidelines, and Lordship will notice that page 52, the entire process of supplying has to be completed on or before 31/12/2025. Page 52, clause F, down below. The tendering process for quotation has to be finalized on 31st of August before on or 31st, and the tendering process open tender 15 September, my lord. That Lordship will find it page 53. So it is not that, my lord, we are not qualified for the tendering process, my lord. There is no basis for that submission, my lord. We are eligible, we are fulfill all the other eligibilities, my lord.
Heard Mr. Record your name or senior?
Senior name, if can
Ken
record it, Mr.
Chaudhary,
Tilpai.
Learned Senior Counsel, assisted by Mr.
RM
RM
Dekha.
Dekha, Learned Counsel for the petitioners. And also heard Mr. We'll say,
Preparing for SSA.
Mr. P. Nayak, Learned Standing Counsel,
SSA.
Learned Standing Counsel, appearing for Standing Counsel, SSA, huh?
Lordship.
Respond number 2. Next parent, agreed by the inability to register in the Shiksha Setu portal, SIKSH, SETU portal for participation in the NIT oblique quotation oblique tendering process or procurement of free two pairs school uniforms to all the students of classes 1 to 7 or 8.
8, my lord.
8 of
Page
government
49.
provisionalized LP, UP and composite schools within bracket elementary level bracket close for the year 2025 to 2016 under Samagra Shiksha, Assam initiated wide guideline dated 08/08/2025, the petitioner, the present petition has been, is prepared, is filed. List of issue notice to the respondent returnable by 4 weeks. As Mr. P. Naik learned, who is for 1? Nobody's appeared.
And Khatane was there, my lord, in the morning, my lord. His name is.
And Mr. Kataniar, NJ Kataniar, then standing counsel for then state council,
Yes, my elementary education.
enters appearance on behalf of no, and Mr. P. Naik enters appearance on behalf of all the respondents. No formal notice needed. However, extra copies were furnished to the learned council for the respondents. Next page. It is the case of the petitioner. It is contended by the learned senior counsel, Mr. K. N. Chaudhary, that the petitioners were awarded the work for supply of free school uniforms to the students of class 1 to 8 of government, provincialized LP, UP and composite schools at the elementary level in the state of Assam as per the guidelines. Christopher. The petitioners have been have supplied the school uniforms to the students. However, in between, there are certain defects in the uniform supplied to the students, which has been rectified. Christopher. The requirement for requirement to participate in the tender process is to be is that the interested the what is called intended bidder or what participants intended participants the vendors has to register themselves to the themselves in the Shiksha Setu portal. List of. However, no, list of. When the petitioners try to register themselves, the portal did not allow registration. Stuff. Referring to the where is that list of
Annexure E, my lord, also will find it page
no.
Page 44.
He submits that
Page 45, the name.
the
of the
respondent authorities when a list while respondent authorities issued a list of vendors whose lab test reports are not as per requirement in the last year when it is wherein the petitioners' names are also included. However, there is no notice to such report given to the petitioners. As per the guideline, that is 0808/2025, it is provided that only those vendors who are registered in 6S2 will be allowed to participate in the tender process. List of the vendors who were blacklisted due to supply of substandard quality of uniform during the year 2023-24 and 2024-25 shall not be considered to participate in the tendering process and also in the quotation process. Mr. Chaudhary, London Senior Counsel, submits that the guidelines clearly shows that the petitioners have been made ineligible, in other words, have been blacklisted without due procedure of law, as no notice or opportunity of hearing has been provided to them. Therefore, they have been made eligible to participate in the tender process, oblique quotation process. Mr. On the other hand, Mr. P. Nayak, London Standing Counsel, while placing the instruction in writing, submits that a meeting was held on 25/07/2025 with the Uniform Suppliers Association chaired by the Honorable Minister of Education, Assam, in which it was decided unanimously to debar those who supplied substandard uniforms in last 2 years from participating in the tender process for subsequent 2 years, which was attended by 4 of the writ petitions, 4 of the petitioners in the present writ petition.
And numbers are also 1, 13, 4, and 7.
It's okay. We'll see. He submits that since some of the petitioners have participated in the meeting where it was unanimously decided to debar those suppliers, those vendors who have supplied substandard uniform to be debarred from participating in the tender process, and the petitioners having been supplied substandard uniforms, school uniforms in the previous 2 years. The petitioner cannot agitate that they have been made eligible without any notice. That's all. Mr. Having considered the submissions of learned counsel for the parties and also perusal on the materials annex, whereby it is reflected that the petitioners have been shown to have submitted substandard, what is called substandard?
Uniform.
As far as
Who shown to have supplied substandard uniforms in the last 2 years. And those who have been blacklisted
May not use the word blacklist, barred.
no, it's clear who have been blacklisted due to supply of it's in your guidelines
Yes.
of substandard quality of uniforms during the last 2 years shall not be considered to participate in the tender process and also in the quotation process. Comma. I deem it appropriate to pass an interim
Lordship,
order.
may I reformulate, Lordship? Their basic grievance is we are not allowing them to register, Lordship.
It's okay, that I've heard you.
To that extent.
We'll
Lordship,
examine all the
to
things.
that extent, Lordship will allow, but so far as tender is concerned, Lordship, let the school.
No, that is, I'm just considering all these provisions, what I'm saying. What I'm dictating is
Yes.
that I've considered these provisions. A tender quotation process. I'm of the considered view that an interim order is called for at this stage. In view of the fact that the petitioners prima facie appears to have not been initiated any proceeding for blacklisting or debarring on the ground of supply of substandard uniforms in the previous 2 years, accordingly, in the interim and subject to the further order, petitioners shall be allowed to participate in the tender process and the quotation process without requiring them to be registered in the what Setu portal?
Shiksha Setu. Lordship,
Shiksha Setu portal, just wait, Shiksha Setu portal. And manually, manually in those schools, wherever the tender process.
Otherwise, tender is otherwise also manual, Lord.
No.
Only registration is.
Tender and the quotation process has not been
Initiated.
completed. Only those schools where it is not completed. Because they have shown some documents that in some schools it's already over.
Not in some of the school it's already over.
It is made clear that the participations of the allowing the petitioners to participate in the tender and the quotation process shall be subject to further order of this court. You may allow them, we may reject them also.
That one line only, Lord.
Yeah, what?
It will be up to the authority, Lord. So.
What?
It is always up to the authority
There,
to accept or reject our
Lordship
tender,
has,
my lord.
what Lordship has allowed only to participate. But ultimately, whether the order will be allotted to them or not, that will be up to the authority to decide.
No, we're only allowing them to participate. You allow them, rejection is up to you.
That one line only, Lord.
Not
That
required,
one
my
line
lord.
only. That one line only.
Acceptance and rejection is always up to the authorities, my
Lordship has
lord.
only
Then
allowed
we'll
them to
say that.
participate.
We'll say that.
One line, Lord.
Needless to observe that rejection and acceptance and rejection of the tender oblique quotation of the bid is always always up to the tendering authority, subject to the conditions, subject to the fulfillment of the condition of the tender oblique quotation.
As well as the guidelines.
And in accordance with law, my lord, in accordance with
As
law.
well as
Everything is- has to be in
Guideline
accordance with
were
law.
not happy.
one,
That's why we're saying condition. Condition of the tender.
apply.
Reply applies.
This is some other case. So we'll not refer those Supreme Court judgment. It's not required.
Yes, my lord.